man. Get in her.
Yeah, cool. Well, thanks. You guys are champions. Thanks for all this and all your efforts.
No
and
problem.
We've deep dived into this over the last. He's been awake to this for a few years now, and
right on.
me just this year. And we've kind of been chucked in the deep end.
Okay.
Me at least. But yeah, if you won't mind, I can ask you questions and.
Yeah, fire away.
We're just going to let you guys know real quick, we are recording this. Okay, so we want to make sure you guys are okay with that because we want to use it as an educational tool. So hopefully that has your blessing.
Absolutely. Yeah.
Okay. Excellent. Wonderful. Thanks so much.
Thank you. So I guess the first thing that we're having issues with is converting the Canadian acts into Australian. And we've come up with what we believe is the correct ones.
Yep.
But we just wanted you to actually just have a quick glance over that to see.
Yeah. I saw some of the call it the subheadings there of the menu items of what the contents were, and just those. I had actually put eyeballs on Australia's, New Zealand's, Queensland's legislation prior. So as soon as I saw that you guys were in the right direction, you guys are absolutely in the right direction. So now it's just a matter of going in and sucking out, like we were suggesting, the appropriate ones and just plunk and play. Now, again, keep in mind, guys, use mine as a guideline. There was so much meat in here, like literally I could probably chop my security agreement in half.
Okay. Yeah.
It's still going to get the job done. I mean, I like to just go ridiculously overboard, and it's so overkill again. So don't feel like you're obligated to hit that bar, because you're not. This is so individual, right? Like that's the beautiful thing with our level of knowledge, fresh people coming in versus seasoned veterans, they're only going to be able to express what they know, and a judge will listen to that all the same. Actually, believe it or not, here's a weird twist in equity. As soon as you start talking like you're super gifted, if you want to call it that, the judges now actually expect more from you. That's right. So, right, versus someone like, well, you know what, Your Honor, I just stumbled upon this truth 5 days ago, and this is all I could come up with. You know what? The judge loves that just as much as guys like me or Dean or, someone doing this for 10 or 20 years. Yeah, the judges love that stuff too. But again, they'll come right down because equity compels them to do so. So don't feel like you have to get to a rocket surgeon level to effectively make all this work. Yeah, no, that's not how this works.
Yeah. Okay. Because I think we've talked, and there's a couple other of us who communicated with where we're looking for, and we're basically all the acts that we're correlating to Aussie, they're all in the PPSA. Yep. So it's pretty obvious that that's the direction we need to be in. Right. And the only thing that we were like, because you on all your documents, not all your documents, but the surrendering of the birth certificate, the adverse claim, you don't mention the PPSA.
Right.
You do, but what we can find is all on the PPSA. So we're thinking that we're probably going to have to use that. And,
absolutely. And so yours is actually a little more streamlined. There you go.
Yeah. Well,
it's good too because it's a federal legislation.
Yeah.
So we can use it for Victoria, Queensland, or wherever. So
nationwide.
Awesome. Yeah. A judge will listen to that. Absolutely. It's kind of strange.
Okay.
As it turns out, as we learned more about this, we actually came to realize we are so surrounded by remedy. We are so surrounded by getting our shit fixed. So when we came in kind of guns blazing, they appreciated that at first, but after a while, when we weren't hitting the right buttons and we weren't making the right directions and we weren't coming across with the correct stuff, the system kind of got tired. And they're like, okay, you guys got to shift gears here because you're just wash, rinse, repeating some of the stuff that's not working. And it forced us to look elsewhere, but through that journey, here we are. So again, guys like you that are just rolling through here, awesome. And again, love the energy, guys. Like it's super appreciated. Yeah.
No, that's great. Thank you so much.
Yeah. Maybe I'll just power through. So one that really stuck out this morning is on the adverse claim. Let's go back on the constructive notice sent to the Attorney General. That's coming from our Christian name with the last name replaced with settler.
Sure. At the very least, yeah. Settler very quickly leads to protected purchaser because that's kind of the same transaction.
That's where we're trying to get at. Yeah.
Yeah.
And then we've seen protected purchaser. So we're like,
Yeah.
what do we need to be as?
Yeah, you know what? Pick one. Those are both incredibly powerful, but when you put them together, even more so.
Okay.
Yeah.
So moving forward, should it doesn't matter who I am if I'm settler or protected purchaser. Could I be both? Could I say both?
Yeah, because technically the purchaser was the settler. It's kind of the same guy.
Purchaser was okay.
He's the guy coming forward and settling all this dirt in the background that nobody knew what was going on. So it's the settler showing up to settle things. And once that's settled and he wipes his hands, he leaves the room and now he never comes back. Now he only reappears as the beneficiary. That's a whole other cat.
Yeah. Yeah. Okay. That's good. That's the settler of the jurisdiction. And you, on your notice of constructive notice, you have a phone number.
Sure.
You're saying you're from memory a private national outside of federal jurisdiction.
Yeah, that was older technology. Yeah, that was older technology that we were using 2 or 3 years ago. It's very effective. Don't let me take anything from it in that respect. But yeah, as long as you're putting protected purchaser and settler on there for now, that tells the judge a whole lot of stuff. And actually, depending on if you're, for example, starting the beginning documents, it's important to convey to the judge that, hey, I understand what the grantee position was. And this is something that we missed, Dean and I, 10 years ago. We didn't understand and fully grasp what the grantee position is. And it's the guy, it's the party, it's the cat who has both halves of the pie and he puts them together. When you have a whole pie, now you can do stuff with it. And by doing stuff with it, we're actually giving back the half of the pie that we don't want. But we weren't able to give the new trustees that old half of the pie because the new half of the pie hadn't shown up yet. We had to show up with our half of the pie, match it with their half of the pie, and then spin the pie and then send them the moldy half.
The smelly one that we don't want. All right, so just back up 1 second on that note with the private living outside of federal jurisdiction. Should we delete that?
You know what? No, that's some pretty serious lingo right there. Again, I used it for 3 or 4 years, and I would still use it today. Absolutely, it's really
okay.
Good. Yeah,
and include a phone number, no address, no care of.
You can do both of those. I like the phone because I like answering the phone now. There's no more running and hiding from bill collectors and all that kind of stuff. So it's actually fun now. So, but yeah, feel free if you do want to see. We're also, back in the day, we were very big on, hey, let's conduct our business in writing only. We actually didn't want to do a whole lot of verbal communication on the phone because why? Because actually our knowledge level wasn't high enough. It didn't take long until these clerks or these people, these hearing coordinators, they'd start asking you a couple of questions and you're like, crap, actually, I don't know. And I didn't like getting caught with questions that I didn't know the answers to. So it didn't take us long for us to realize, okay, we got a little bit more digging to do. We got a little bit more procedure to learn because they really slay us with procedure. If everything isn't just perfect, they bounce it. And, we've been dealing with that for 10, 12 years. But the cool thing now is once you endorse this certificate properly, once you attach the value, and once you guys are understanding what the adverse claim is, once you put this package together, equity regards that as being done what ought to have been done. Now, with the fact that you did that, that is step 1. You can't jump to step 5 if you haven't done step 1, which is kind of what Dean and I were. I don't want to say we were shooting ourselves in the foot, but it kind of towards the end there, it kind of became that because we hadn't perfected our interests. So without that critical component, you can talk all the admiralty, you can talk all the, I don't want to say freeman because that's, we know,
except just say gibberish.
Except for this guy's surname. So see, this is where your surname
it's changing again. Don't worry.
Too funny. But yeah, so we were brought to a whole other level where we had to really understand the procedure. And then somewhere in the middle of all that, equity says, hey, just perfect your stuff, send it in so that it's rather intelligible. We don't care about the formalities. We don't care about the technicalities. Just get the meat and potatoes of the spirit of what you're trying to convey. Get that down on paper, in crayon, on a paper towel. It doesn't matter. As a matter of fact, another beautiful loved one friend of ours here from Quebec, who has just messaged us in the last several days, was mentioning that she has made tremendous progress with this as well a number of years ago, and she did it without a stitch of paperwork.
Yeah, well, okay.
And I completely concur with this. I completely believe it's possible, and I would love for us all to get to that level. However, how do you get to that level of capacity to know this stuff unless you're doing a bunch of writing? Okay, no, she may have fallen down and bonked her head and woke up and was able to speak German and she knew all this stuff. Those cases are very rare. That didn't happen to me. So I'm the type of guy where I'll learn a lot, and I'm guessing you guys are too, and pretty much everybody else. There's going to be writing involved for now until we have the wisdom and the standing to just literally stand in front of a judge and just wing it. That takes some talent. That takes a little bit of, hey, you better know a few things at least, enough to convince a judge. Because if you just come out of the blue with no history, here again, right? So Dean and I are actually battling a lot of our history because we had such a conflictive attitude back in the day. I might as well just go on the record now and say, like, Dean more conflicted than I was. However, come forward now with a reasonable understanding and comprehension of what's going on. Hey, Your Honor, I understand. I realize this, and I've come to know this. You give him a few blurbs. Now, if you were to show him that birth certificate with that coin on it, like James, you rolling into court here in the next little while, you have, what I would be doing is, as soon as you have that, I'd be faxing that to the courthouse now. I'd be sending that care of clerk in Chancery, actually, civil side.
Yes.
Now, when the clerk gets that, she's going to be like, what do you mean Chancery? What gives you the right to invoke the court of Chancery? That's the proverbial key that we've been looking for 20 some odd years. And the proverbial key is now that as soon as your endorsement shows up on that certificate with that coin and that little blurb is the security agreement right on the certificate.
Gotcha.
So once you do that, you actually don't need the 4-page version of the security agreement. No, the trustees will actually take over because they know, hey, that's actually a version of a security agreement right there. You in that short blurb, I don't know how many words it is, but let's say it's 38 words. Out of those 38, there's a couple of the and is's or whatever type little words, but the rest is surgical precision. So that when these people, when these clerks, when these authoritative figures, judges, registrars, when they see that stuff, they're instantly compelled to respond and act appropriately. Why? Because in British Columbia, for example, here it says in the Law and Equity Act, I believe I want to say section 7. The judge must take cognizance of equitable estates and interests. Means that court, that judge, they must take cognizance. They must acknowledge it. They can't dismiss it. They can't push it to the corner of the room and say, well, I hope nobody saw that. No, they can't do that. Now, again, the equitable estate shows up the moment that you do your birth certificate magic. That's the equitable estate. That's the equitable interest rising out of the dead, literally. So what goes into the hole now that was in the ground? Well, this is where the tables flip. And we actually put that person into the ground, into the vault. Where the unders undertake that person, they look after it, they manage it, they water the flowers, they make sure the dogs don't pee on our marker. They take care of it. So that's kind of the whole systemic background of the ministers, especially now taking on a new undertaking to perform duties and obligations. Why? Because a trust has arisen. A trust is provable. A judge can, this is where the trust actually comes from. The moment you write that stuff on the birth certificate and add the coin and the value and the intent, that is the trust. That's it. It's something valuable. It becomes part of an agreement. And now you're putting it into the party's hands that you believe able and capable of dealing with this thing. And that's where the undertaking comes in. Hey, I'm no longer going to breathe life into something dead. Let's put this thing to rest. Let's literally let it RIP, give it a memorial, say, hey, a title has passed. Something has passed, like literally energies have exchanged. What's left is not what used to be there. There's something clean here now, something shiny. It might even be on fire. Whatever.
Cool.
Right?
It's in their hands. It's all that matters.
Yeah, that's right. And now again, a judge is looking at all these expressions and they're like, okay, yeah, this guy deserves a shot. Now he might just say, okay, well, what else are you after? And your response to that is going to be, well, Your Honor, I know equity will not allow a trust to fail for want of a trustee. Okay, so that's one of the equity maxims. What does that actually mean? That means, hey, I have a trust over here, Your Honor, and because I'm no longer the trustee of it, I know this won't fail because this is super powerful. So, Your Honor, would you mind taking this and making sure that a new trustee is appointed to manage this, because it's not me anymore. You walk away as the beneficiary. I just was the settlor right there. As soon as I say, hey, I'm no longer the trustee, I'm the settlor of this thing. And as soon as you put it into the possession of a third party, boom, the arrangement has changed. And the judge has to agree. He can't say, no, I don't see a trust there. He'd be lying. And we have seen way more honor in the system, especially as of late. We saw some incredible examples of it. I won't probably get into it on this meeting. However, Dean went through some pretty cool examples of seeing how there is honor in that system. And as a matter of fact, we never really spoke about that stuff publicly. So again, more gold coming down the pipe there. But yeah, don't get me wrong. There is a lot of honor in that system. It would actually blow you away.
Yeah, right.
Yeah. Right. Yeah. Well, that's kind of leads us to our next question. When walking into court, which you kind of just spoke about,
Yeah, walking in the court, he's going to say, what's your name? And you're basically going to say, well, Your Honor, as the debtor, because that's implied, you can't get around that. So you're just going to say, well, Your Honor, as the debtor and under terms of a security agreement, my name is private. But
if we haven't done this, the security agreement's on the actual.
And he's going to say, what do you mean private? And literally you could say, well, Your Honor, I would like to enter evidence of a securities agreement and evidence of the certificated security with a security interest attached to it that I would love to put into the possession of the sheriff standing right behind me.
Okay.
And then you can say, Sheriff, would you mind taking this up to the judge so he can see what I'm talking about? As soon as you pass it up, because this is the sheriff's role. You never really get to walk up to the judge and hand stuff to the judge. No, that's the sheriff's job. And the sheriff and the judge has to take knowledge, or he has to be able to look at the evidence you're presenting to him, because it's evidence of an equitable estate.
Yeah.
Under an adverse claim, as soon as you tell the judge, well, Your Honor, rather than tell the court what my name is, can we just enter onto the record that I'm the settlor in possession of an adverse claim?
Yeah, perfect.
And that's enough where you could suggest, Your Honor, I motion that we seal this because I got private trust matters coming out of my file. Can you see these yet? And right there, the judge will be compelled to seal the court. The public is not allowed in. They're not allowed to see what's about to happen. And the judge is probably already shaking because he's already looking at the birth certificate with a coin attached to it.
Yeah, totally.
He knows what's about to go down. And because you're asking the court's permission, Your Honor, I would love to enter this particular piece of evidence. Will you allow this, Your Honor? And he has to say, well, what do you got there? And you can say, well, I got evidence of a perfected security interest attached to a certificated security with valuable consideration under an adverse claim.
Yeah.
The judge literally is like, he's probably hovering right now. He's probably off of his chair. But again, there's no way he can let the public in to see what's about to go down.
Exactly. Yeah.
And then now really all the judge is going to ask you guys, he's going to say, well, James, what's your intent here? What are you going to do with this certificate? And you're going to say, well, I would love to assign that 100% security interest to new debtors, to new trustees, because as a settlor, Your Honor, who's the trustee, Your Honor? If I'm the settlor, it has to be somebody. And he's standing probably right there. And the judge has to say, agreed. Boom. So the Crown prosecutor, who was just prosecuting your case, just becomes your trustee. Only if you showed up with the certificate, though, right? A man with standing is gonna call it, let's go say he's bonded. When you're bonded, you don't need to be insured.
Gotcha.
Yeah. It's kind of the same banking technical term, but we have to be insured publicly. Why? Because we haven't perfected our bond. Without perfecting your interest, without perfecting collateral in your bond, well, you have to be insured. Like there has to be some kind of commercial commodity type blanket system that's going to cover you in case of accident, misrepresentation, or you know how the story goes. But until you perfect those interests, you have to be insured. Now, once those interests are perfected, you're automatically insured. This was evidence when Dean took my truck and he went to cross the US border there, like I don't know, 5, 6, 7 years ago. He had a 7-hour meeting with Department of Homeland Security, arguing about the birth certificate and all this, that, and the other. And because he was live streaming it to YouTube, and I think there was like 40,000 people watching.
Yeah.
Oh my God.
The agent actually says, you know what, there's no, we don't care what you say. There's no way we are going to let you through today. But so 7 hours later, what this actually boiled down to was they admitted that, yes, the birth certificate was a bond. So this is what the agent says to Dean: I can let you in, but I can't let your truck in because the truck's not bonded. And Dean said, well, give me a pen. I'll write that on the birth certificate right now. And the agent actually took the pen back and pushed the birth certificate to Dean and said, no, sir, that won't be necessary today. And then they asked him to leave.
Yeah.
So if Dean had just expressed that intent on the birth certificate prior to showing up, right? Have your shit perfected now. Don't go do it in front of the judge. So hey, judge, look what I did. Look at the value here. There's no way a judge can say, well, I don't see a trust here. I don't see what you've expressed. I don't see the terms and conditions. I don't see the legislation that you attach to direct the new trustees. I don't see your special squigglature. Okay, I made that one up. And I don't see the coin here.
Yeah.
No judge is going to be able to say that. And because the sheriff just brought this up to him, the judge is now in possession of it. As soon as the judge is in possession of perfected titles and perfected security interests, that takes the handcuffs off the judges as well. Because now they can administrate a whole other level of court. Guess what that court is called? Say chancery.
Oh, chancery.
Chancery?
Chancery.
Because the public's not allowed into chancery. Why? Because they're dirty. Chancery is the ecclesiastical courts from like thousands of years ago. The king's living spiritual connected to God consciousness courts.
Yeah.
Those were his courts. The bar attorneys, they came up with a whole other set of courts. That was all under corporate law. God's law, spiritual law, natural law, everything but at law, that's all equity. That's where chancery's home domain. Chancery can leave its little domain and walk into legal and say, nope, we've seen enough. And they can literally pluck out a case from the at law or the legal world and say, no, we're taking this over to chancery. And public, you're not allowed. So in public opinion, public policy, public legislation, whether it's provincially, federally, or otherwise, public law is no longer allowed into your case.
Interesting.
Oh, wow.
See, the public is excluded, which means the public's not allowed in. So if the public's not allowed in, well, then what's here? Well, what's here is private law, private international law, equity, the 20 maxims, however.
Yep.
That's the new substantive law that we're operating from. Why? Because the plaintiff gets to set the jurisdiction. The plaintiff setting the jurisdiction means the plaintiff brings the jurisdiction. What are we bringing? Oh, we're bringing equity. And man, is it loaded. All you need to do is have a few maxims down. You know, again, there's 20-ish. I recommend you get your heads wrapped around 3 or 5. One gets the job done. But man, when you guys can sling 3 or 5 of them together, you slay the entire at-law system. And as soon as you show up with that perfected security, you've already slayed the legal system. Now, the trick is to just understand, hey, no, I'm the beneficiary of this thing, and just make sure that they never trick you into being the volunteer for the trustee position again. And you know what? There's no way a judge is going to do that in good faith and good conscience anyway. Why? Because he's holding something here that is converted. It has literally converted the record. Now, he's not going to go out of his way to try to trick this and spin it and kind of make it something. No, we're all tired of the games, and so are the judges. As a matter of fact, I had it on good authority. I'm not going to say where the authority came from because I don't want to get her in trouble. But let's just say that she was up there in the court system, and she had mentioned to me several years ago that they were actually sending judges from the United States to help train the judges up here and get them ready for what's about to come.
Right.
Crazy.
Yeah. So they're expecting us again, but because they can't come out forthwith or forthright and say, hey, you guys are close. You guys just need to do this, and this. No, see, that's not fair. Because there has been a lot of people put in a lot of effort, made a lot of sacrifices to get to where we are.
Most definitely.
Now, for them to just bend over and take someone fresh who's actually experienced none, who's actually put in no effort and say, just do it like this and you'll go right through. As a matter of fact, guys, in the background, all the public servants, if you want to call them that, all the civil servants, they're very heavily monitored. I mean, I know there's a lot of weird crap going on in the world right now, but in the background, so there is still a lot of goodness going on in the background. There is a lot of honorable people. There is the equity is still here. Let's just put it that way. It always will be, and it can never be erased. And now that we're raising such awareness to this, with our energies, our passions, with the stuff Dean started and the few handful of gentlemen before Dean, man, this thing has sure evolved in the last 20 years. And yeah, what a time to be here. So yeah, for you, James, rolling into court, send a fax or an email of this to the judge or to the clerk, even, really saying, hey, whichever judge respecting this case that ought to be heard on such and such a date. These are just some of the particulars I would like to furnish his honor or her honor with ahead of time, just so that there's no surprises, because I'm trying to act as honorably as I can.
Yeah.
And although I may have not completely landed my stuff at land titles, it is my intent to do that because I am trying to express a security interest. I am trying to transfer a security interest. I have named a party who is the secured party. That secured party happens to be the successor in interest. So, Your Honor, I've done some stuff. I've got my head wrapped around the basics here, and I'm actually calling on and I'm electing for the court to come to my aid and assistance. I'm not going to claim to know all of this, Your Honor, but I know a trust cannot fail for one a trustee. And because, Your Honor, I know what this is evidence of, and I know you know. So let's just cut the crap and let's just get on with it. And trust me, guys, he's excited because, the tithes kick in now. They actually, as administrators, a whole new monetary potential has just opened up for that court. Not just that judge, right? The judge he oversees an umbrella of an immense machine.
Yeah.
All the mechanisms in the background that are pushing all this stuff, it's immense. I'm like just blown away at how large that machine really is. And it's up to us again. When I was speaking earlier about Dean and I having a conflicted opinion with, we were always aggressive, or we were always, that system needs to be taken down. It needs to be it needs to be scrapped and rebuilt. It's like, no, it didn't. We just needed to learn how to navigate it properly. And that's what we've come to really, really appreciate here in the last little while, especially now that we've got this perfected security interest thing going. Again, it has taken me almost 5 years to get that one figured out. And I don't just do this as a hobby in my spare time. No. So when I say 5 years, like, it's a pretty dedicated 5 years. There wasn't, I know. So there's a lot of effort going on. And again, it's comforting knowing that, again, this friend from Quebec that just happened to leave a message here on our Divergence platform there the other day, suggesting that she has pulled all this stuff off without the paperwork. And you know what? That absolutely warms my heart.
Yeah, that's amazing.
That tells me that it is possible. And I always felt it was. But again, how do we get to that level of wisdom so someone could literally just walk in and belt it out? Well, I think we're on track. We're very close. Again, I would rather have all loved ones, friends, and family that are doing this stuff. I'd rather them be more capable and never get caught without having an answer. Is that realistic? Well, no, not really. But I like shooting for the unrealistic.
Yeah. That sounds good. Well, we're ready and willing to go, so.
Okay. So when is your court appearance specifically? Is it today?
No. So it's Monday next week.
Oh, perfect. Okay. Then we got lots of them. Well, then you know what? While I got you here, then we're going to talk about something called an abatement.
Yeah.
An abatement is huge. I've stopped 4 mortgage foreclosures with this one. This is deadly. Wow. I did this even without perfecting our security interests. All the abatement means is, hey, jurisdiction that's calling me or that's summoning me to appear as a fiction, as we know, for whatever that case is, whether you stole a chocolate bar, you didn't make your mortgage payment, or whatever, it doesn't matter. What you're basically telling to the court right now is, hey, you don't have the jurisdiction to deal with who I am.
Right.
In one word, that's what it's saying. And as long as you can provide a little bit of substance, the judge literally blows right over your case and says, Crown, call your next case. Abatement, literally, an abatement slams the door. Literally, guys, when I say slam it, and here's why. The opening clause, the very next line after a plea of abatement generally considered. A plea of abatement to the premises generally considered. Does that think how it? Actually, I got it right here. Plea and abatement to the process generally considered. Yeah, okay. So the very next line, it basically says this: the defendant no longer possesses the character in which he or she is being sued.
Well,
Okay, so if you don't possess the character, who does? The successor in interest does. Therefore, take him to court. Don't take me. I'm no longer liable for this thing. You got the wrong party, Your Honor. There's been a conflict. There's been a confusion of titles. As soon as you tell the judge that, he's like, what do you mean there's been confusion of titles? You can say, well, I showed up to court with my perfected title. What does the crown got? The crown's got nothing. The crown's got nothing but trusteeship. Oh.
Yeah. That's beautiful.
It's a big deal. So I'll punch that out for you. Like I said, I want to say the old working version I used for this bank, it was about 2.5 pages, 2 pages long. But I seriously think I can probably knock this out of the park in literally 3 sentences.
Okay. All right.
Yeah.
Even without paper. Just
Yeah.
say it.
So again, this is where it's just going to get simple. Okay. So even though we're talking about simplifying the shit out of all this process, yeah. But you know what? There's still, instead of taking 5,000 words, we're going to go to 500, and then we'll go to 50. But you know what? The context of the word still has to be sharp.
That's
It has to be accurate, and those words still have to be a little bit technical. So unless you're absolutely going to refuse to go and Googly some definitions of words, I could probably still spin, well, what does a beneficiary mean? Well, if I had to explain that to a 5-year-old, I'd probably say it means you get stuff because of someone's promise.
Okay.
And a 5-year-old would probably get that.
Mm-hmm.
So do I want to phrase it like that to a judge? Maybe the 5-year-old does, but right. So again, it's all relative. So wherever you are in your journey here, equity matches it's such a comprehensive way to be. And again, don't be afraid to ever think, I have to leave a completely old mindset, an old paradigm, an old way of being behind me. Now, I don't have to tell you guys that because you guys are on the other end of the screen here. But for a lot of people that are, they get caught. There's no way. They have so many attachments. They can't let go of that old world, that 3D world. Not a chance. Yeah. So they're stuck they're kind of stuck on a hamster wheel of pain that they consider to be pleasure.
Yeah.
All right. And some of us that are more aware and more awake, we're like, hey, I understand the whole pain pleasure experience, but I'm just a little bit more inclined to the pleasure for now. I think we've all kind of suffered and had enough of the pain thing. Yeah. And I'm just blessed to have the opportunity to give guys like you and others the wisdom and the knowledge that we've come across. And again, you'll never hear me say I know it all.
Yeah.
But between Dean and I, we do. and our other teammates here, right?
Plus everyone else.
Yeah. Okay. So, and by everyone else, I'm talking about everyone else who's also pursuing the truth, whether it's the truth medically, whether it's the truth spiritually, or whether it's the truth, whatever. Right. Yeah. The truth is such a vast, broad topic. You can't define it.
That's right.
So, can I run something else by you?
Oh yeah.
Getting private witnesses into the courtroom.
Yep.
Do you see a requirement for this?
I would say, you know what, if all that they're going to do is when the judge clears the courtroom, he's going to say, who are these? And you can instantly say they're part of my household, or they're with me, or they're my private witnesses, or they're my next friends. See, that's kind of interesting. The concept of Mackenzie friends and next friends, it actually doesn't fly in the public at law world, because Mackenzie friends and next friends are actually relying on doctrines of equity. And those doctrines of equity cannot be heard in the legal system. So although we see next friend in their legislation, we can never get our next friends into court properly. Don't get me wrong, it has been done, but it is so rare. Let's just not even go there. Come with clean hands, come with perfected interests. And when the judge starts seeing this thing unfold in his court, literally, guys, it's like Hiroshima all over again, right in that courtroom. But in a good way, right? It's an explosion of rainbows and unicorns.
Yeah. And you've touched on this just previously with the noticing the court. Like I have a question, special attendant, should I put this in? What should I say? But you've already kind of explained it.
The abatement that I'll prep for you here, and give me a day or two to get that done. Because as you guys know, we're trying to punch out a whole bunch of content as well for the website so that all these pages are interactive. And I do want to let you guys know all the legwork that you guys are doing here by throwing these particular legislations at me, whether it's Australia's Land Act or all these things that you're throwing at me. Like I'll just dive right into that because so you guys are literally streamlining it for me as well.
That's
I
right.
don't have to go digging. I can go right into what you guys have provided.
Yeah.
So there is a kind of little neat, a very overwhelming sense of contributionism here. Michael Tellinger would be impressed. Speaking of which, I got to contact him again soon. So again, when you show up with those good interests, the judges are gonna be. This is where they bow. Dean and I and a few others have had the judges bow. Judges running out of the courtroom. I don't want judges running out of the courtroom.
No, you want them on side.
They're gonna leave to close this public case. They have to leave. They literally have to leave the room. That matter's now settled. It's over. It's done. Then he comes back in under a fresh set of circumstances. So you were the defendant over here, and now you come in as the plaintiff. Now you come in as the guy with the power. Now you come in with the guy who knows some stuff about equity. You come in with a perfected security interest. You roll in with a security agreement. You start pointing at the prosecutor, telling him, Your Honor, this is what I require. And I require, and I require, and I further require. Guess what the judge's answer is going to be? Is there anything else?
Yeah.
Interesting.
What else can I help you with?
What else?
Yeah.
Because why? Here's another equity maxim. Equity will take jurisdiction to avoid a multiplicity of suits. And all that's really saying is, hey, we're going to deal with as much shit as we can right now. So bring it. So show up to court with your list. Don't stand there thinking, well, no, just bang.
Yeah.
He wants to see you prepared. He wants to see you organized. He wants to see that you knew what was about to happen. That's how he knows you're trustworthy. When he asks you a question, you go, yep, right here. Boom. He asks you another question, you go, yep, right here. Boom. And he's like, I see no reason why this court cannot grant this order today. And it's a big deal. So the abatement shuts down the at-law side and it removes it, literally like carving a cancer out of a body. Now it brings it in under a whole new jurisdiction where you are bringing the rules of the game, and those rules of the game are equity, the 20 maxims. Beautiful. Get your heads wrapped around 3 or 5 of them. Surgically. Awesome.
I can email them too.
Yeah, we'll email it to you guys. We're going to be posting.
We've got the maxims. I've read them over. I didn't know that there was equity maxims and common law.
Yeah, there are outlaw maxims, but you know what? They don't quite embody the same spirit that the equity maxims do. So
we focus on equity.
To put it in terms that the 5-year-old can understand it, when equity and common law fight, equity always wins.
Equity prevails. Yeah.
Equity prevails.
Yeah.
Done.
Well,
I've got a question. So Daz, we've been going through these legislations, okay, and like we said, we found a lot under the PPSA, under the Australian federal legislation, and basically, like I was going through your original paperwork, and I wrote down something like it was like 80 different legislation sections and that. And then I went through those to learn all about those, and and then I'm trying to find them, and I remember spending like 2 hours just trying to find one, right?
I know.
In our Australian legislation. And I'm like, this is going to take forever, right? It definitely helped my knowledge of a lot of the equity stuff you're talking about.
And that's why actually, although we are providing a lot of the answers and a lot of the remedies right here on the surface, I so encourage people to dive in and just give it a try. Because once you have, like you're suggesting, once you have a little bit of that understanding, and you can start to put these dots together, and you can actually start to see this image starts to appear. And when you're able to direct the image or direct the production, when you're able to control the movie, guys, a whole other world just opened up. So for those that want to cheat and I don't want to say cheat, for those that don't want to put in the effort, they're actually kind of doing themselves a big bit of a disservice, because they're actually holding themselves back. When we're making it so simple by saying, here, just take a look at these specific ones, you will start to feel a flow. You will start to see a puzzle appear. And man, like I said, once you guys can control that puzzle, that's where the milk and honey, that's the holy grail right there.
Absolutely.
Yeah. And it's like, if you had all templates, right? Okay. And you just fill them out, and then you go into court, and then the magistrate asks you a question, and you're like, I don't know, Darren told me how to do this.
Yeah.
So, then you're just going to look like a fool, and he's just going to absolutely annihilate you.
Yeah, that's right. And as a matter of fact, we've actually had judges say to friends of ours that have rolled in with our paperwork, the judges ask them, did you write this?
Yeah, right.
And what do you do? So what do you do? Do you lie or do you tell the truth? Right there. The judge knows if you wrote this or not. Why? Because you've never produced a piece of paper that looked like this before. This is so you're trying to tell me this is your first crack at it?
Yeah.
No.
And your vernacular as well that you're using, like he's like, this doesn't add up.
Yeah, right. So yeah, they know whether you wrote it or not. So here's your answer. No, Your Honor, I did not write it. However, I do know this, and I do know this, and I do know that. Give him 3. What do you know? I know I created a trust. I know I perfected my security interests and I assigned them or I transferred them to a new party. That second one's a doozy. And number 3, all those intentions were to A, correct the record and create a permanent trust in equity known as a life estate.
Yeah,
those are the 3 that you really got to say.
Yeah.
Now, when you back that up with one more maxim, and you can wrap that with say, equity will not allow a trust to fail for want of trustee, or equity regards that as done as what ought to be done, or equity will not allow a statute to be used as a cloak for fraud.
Yeah, that's a good one.
Here's another big one. Equity shall impute an intention to fulfill an obligation. Oh, that like, well, I don't want to say what that just did, but
it dropped.
It dropped. Yeah, like seriously, these are big mic drops that a judge is looking at going, whoa, I would love to administrate this estate for you. Why? Not only is this guy seeing dollar signs, but he's seeing again the most honorable thing a man or a woman can ever do. And these are life-changing moments. Like if you happen to hit your knees in the courtroom and start bawling, don't feel like you'd be the first one to ever do that. Because that's how impactful all this truly really is. And I mean, you can ask anybody that, Dean or I have had a direct influence over for, let's say, I don't know, more than 2.5 minutes. People pick up on it right away. The truth resonates with people. It's like we all knew this inherently, but we didn't know where to look for it. We certainly didn't know what it smelled like. We were so in the dark. But now that some light is actually being shown, right, and people are gathering, people are coming together with all this like-minded spiritness and all this, all these incredible emotions. We're literally coming to life. Like we're literally poking our heads up for the first time ever. Yeah. And the judges are waiting. They're sitting there waiting. They're so happy for us in the background, but again, they can't say anything. So it's incredibly, I don't want to say demotivating for them, but it's incredibly discouraging, right? When they see us ram our heads into the wall for 20 years, at some point they're hoping, wow, we really hope that these guys,
get it.
And you got to look at it from their perspective too, right? So all day they've got the most boringest day where everyone's coming in being bitches. Yep, Your Honor, bowing down to
arguing
him. Arguing. Yep, and then you've got people like the freeman of the land, and they come in and they're belligerent, and he's just like, just must do his head in.
Yeah.
And then those people of power sometimes appreciate when someone comes in and challenges them at their level.
Yeah.
And they're like, yeah, shit, this is actually really like mentally stimulating for me.
Sure. Yeah. You know what? And the judges are sitting back. They know what we're up against. And guys, if we were to draw a picture, if we were to try to describe the uphill battle, if we were to tell you how big and bad and scary those dragons really are you sure you want to go slay them? Try to. No, you know what? Because most people would be so defeated, get not even getting started, they would give up before they even start. Now, this is where the judges, again, through this third-party friend of ours, basically telling me, like, hey, I've actually seen every piece of paperwork you and your brother have ever written. It's all flowed across my desk. And in as much, the system is so excited that someone is actually finally doing something.
Wow.
Again, she can only tell me so much. She can't tell me, all the classified stuff, top secret stuff, so to speak. But yeah, it was very encouraging to say the least. It really was. Yeah. And for her to continue and suggest that, hey, even though they're judges, they still need education too. They still need to be brought up to speed. They need to be made aware of what's coming down the pipe. And it's not like we didn't come in and make a big splash, right? Like they know we've been coming for 15 years. So this is either the longest episode of foreplay I've ever seen.
It is.
But there's something to be said about knowing the body. I can close my eyes and run my hands over this body. I'm just gonna do that for a second again.
Keep going.
So you become so familiar with it, you can massage this thing in such a way you can get all the oohs and all the ahs, and that becomes very important. It's very stimulating. It keeps you motivated. It keeps you going. It keeps giving you a reason to get out of bed tomorrow.
Yeah.
And as soon as you start having a level of wisdom where you can actually start sharing it intelligently with other people and actually bringing their wisdom up. And again, right, like, I don't want to say daily, but we are always running into I don't want to call them the non-believers, but that's essentially what they are.
Yeah.
And I actually enjoy the challenge in trying to take the non-believers and drop seeds, show a little bit of light, provide a little bit of wisdom, provide something new, something different from a different perspective. And, if it winds up, you have to part ways and nothing truly availed, don't let that stop you from trying again. Because you never really know what those seeds turn into. Sometimes we're brought into knowing later, or something happens that there's evidence of it. But you know what? Never, ever stop trying to drop these seeds. And again, you guys are doing it right now. And when we post this video for the rest of the loved ones here to watch again, that's all this is really doing, is planting seeds. And we don't come with the belligerent attitude anymore. Yeah, back in the day when we were doing this, it kind of seemed to get a little bit of attention. The squeaky wheel gets the grease. But you know what? The grease didn't turn out to be what we wanted it to be. There's a lot of sand in it still.
Yeah.
It didn't feel good. So hence the whole new redirect. And that's where perfecting the interest just literally fell in our lap. It is literally that powerful. Send the court the heads up on it there, James. Whether we're going to do that by fax or an email, I would suggest probably both, because I don't know how fast the mailing system is there right now, but if you were to get it in the mail in the next day or two, that's cutting it pretty close for next Monday.
Yeah.
So let's go right to
directly.
we'll go right to fax and email. And you'll be surprised at what this yields. Now, your next question is, okay, well, when I send this stuff in, do I still have to go to court? I would.
Yes.
Get your stuff on the record. Roll in there and get some equity maxims down on the record. As soon as you do that, okay. So again, this is when we're walking through the valley of the shadow of death and not fearing evil. What that's actually talking about is walking into court. We're walking into court knowing, hey, equity is going to save my ass. Although I'm going to lose publicly. Why am I going to lose publicly? Because the public system won't hear my equitable defenses. Because this jurisdiction cannot hear my defenses, there's my reason for moving to another jurisdiction. And the judge has to agree. Boom, you're instantly in chambers. As soon as that courtroom is cleared and sealed, technically you're in chambers. Now, you may not be in his private chambers where, you're looking at pictures of his wife and kids and their dog. You might still be in the public venue, but once that door's sealed and the sheriff boots everybody, something just happened. And then he's going to start asking you, like, well, what would you like to do? Tell me what you'd like to do. When the judge asks you what you'd like to do, guess who has control?
Yeah, that's right.
He's asking the question. We're giving him the answer.
You have control. Why? Why do you have control, guys? Because you don't have possession. Sent possession, registered mail to those guys.
Okay, I've got another question, Daz. Obviously, when we send it off, it's in someone else's possession. Say in James's instance next week when he's in court, say like if he goes to hand that to the sheriff, before we can send this off, he has to hand it to the sheriff. What if the sheriff says, no, I don't want to touch it. Like, I don't want to be involved in this.
Say, Your Honor, I know no trust can fail for want of trustee, and I got one here. Can you please instruct the sheriff to accept my gift?
Okay. Yeah.
As soon as you say the word gift, that's instant equity. There are no gifts legally.
Yeah, right.
So depending on the words and the context and the way we spin it, use desire and I require. Like, it's like the thinking words. The emotional, Your Honor, I feel. How does a fiction feel?
Yeah, that's
right. Fictions are cold and probably slimy.
Right?
Unless you heat them up, but that's, you're walking in with compassion, you're walking in with emotion, you're walking in with spirit, you're walking in with evidence of, call it life.
Yeah, cool. All right.
Should there be a motion put forth to dismiss before I need to?
That's what the abatement does.
That's the
That is the abatement. What you're asking for it. That's the abatement.
Wow. You
just slap it on that. You just file it, fax it, email it, all the above. Show up in court with it that day, just in case that. Well, I never got that email.
Yeah.
You can say, well, that's good because I brought 3 other copies today.
Take one.
So take control. That's what we mean by control. And when you walk in smiling because you know what you're about to do, the judges see that and they're like, oh, what do we got here?
Yeah.
And when you, because he's already looking at something you faxed him 2-3 days earlier, he knows what's coming.
Yeah.
But he still has to put on the public magistrate
Yeah.
illusion, persona,
Yeah.
that illusion. He has to maintain that composure. So Dean and I used to love getting the judges pissed off, and we used to love creating all this controversy and watching people run out of the courtroom. It's like, yeah, okay, you know what? Been there, done that. We're actually here to capture the moment and make it as effective as it can be. And Judge, here, you're the witness. I need your endorsement. I need your seal. I need your court approval on what I'm proposing. And the judge is going to say, well, let me see what you're proposing. He's going to pretend to read it, but he doesn't even have to, because he can tell by your composure, and he can tell by the first like 3 words. He knows there's enough substance here. He's going to look at the way you signed it. He doesn't even need to read it. He already knows. And he'll say, I will sign your order. What is it? What order are you seeking? So the old version of this was, I require an injunction, I require an accounting, and I require the appointment of a new receiver manager. The system now doesn't like to call it that. The system now likes to call it an order declaratory for the rights of the parties. So how do those link? Well, the order declaratory of the rights of the parties is suggesting, Mr. James, the plaintiff over here, he's got something special, something that the defendants and the trustees don't have. Signed. So what is it you have? Well, you have your equitable rights. You have your equitable interests. You're running with equities. They're running with legal. Who wins? Who has control? And once you do this stuff on this certificate, guys, this cannot be undone. The judge can't take this and go, well, let's just pull the coin off of here and let's just erase all this stuff and let's put it back in the mail and pretend I didn't get it. Yeah, no, that's not how this works. Again, there's commercial value, an incredible commercial value that we are bringing that was never there before. So that whole machine in the background now lights up. Even the sand and the grease still gets these wheels to turn. And the system, when you bring enough substance, the system now comes to your aid. It now comes to assist. It looks and says, hey, you've brought enough good stuff. We can work with this. And if the judge doesn't like your stuff, he can literally cut it in half. He can literally draft it brand new. All he needs to see is your intent. What did James intend to do? Well, he brought it to me completely backwards, completely upside down and introverted. So I'm going to scrap his version because it was crap. And I'm going to rewrite it for him. And we've actually had judges do that. Not me specifically firsthand, but very good friends of ours have actually had that in the States, which I was alluding to there in the other video the other night.
We heard
Judge writes on the back sides of the pages, 14 pages in purple ink, no capital letters at all. Is that normal? Yeah, no. Do judges make mistakes in chambers? Yeah, no, not really. These guys know what they're doing. So it's pretty good. It's you can take that on its merit, that there's some rhyme and reason to it. Absolutely.
Can I just run something quickly as well? So the first thing I'm going to do is the formal constructive notice, and then I'm going to do the adverse claim to the Attorney General. Sure. Should I do that? Because I have time. I don't have a lot of time, but I have about a week or just under to get this off. Should I send it to the Attorney General and then send the same thing basically to the sheriff, or just make a copy?
Yeah, we're going to send one to the judge or the magistrate presiding over the matter.
Yeah. So send the original birth certificate with the coin to the judge. Attorney General, to the judge. To the judge. Yep. Gotcha.
Send it to the judge. The judge needs to be in possession of the original titles so that he can make a report. He can create a court order granting the legal title because he's got the real one. He has to have it in order to grant it. If he doesn't have it, how do we expect him to give it?
Okay,
makes sense.
Right.
So is it, in that scenario, is it better to send it to him before court or bring it into court, seeing that we've got,
you know what?
Does it matter?
I'm going to suggest send it to him ahead of time, because you don't want this grenade going off in the court. It puts such stress on them, and because they all take this very seriously, I'm more of, hey, this is what I'm going to do. And let them develop their contingent plan and let them develop a course of action so that, and again, this is all being done very cordially because it's being done in good faith, good conscience, and good reason. You're coming with clean hands. The judge can no longer throw you to the wolves. He can no longer feed you to the sharks. No, those days are gone. So you'll be shocked at how well you are received and how you are treated. Tamara,
sorry. Go ahead.
Well, I was just gonna say, like, we've had instances here where these ladies are actually taking their control and rolling into police stations and actually laying some serious smack down, to the point where, like, well, I never even got that far.
Should I send the formal constructive notice first, like it's done, it's ready, to the courts?
Oh yeah, send it all as one package. That constructive notice, send the original birth certificate, send the security agreement and the affidavit.
Yes.
Send that whole micro package right to the judge. Here you go. Send a copy of that to the attorney general, and you could even send a copy of it to the sheriff's office. Say, this is what I'm going to do next Monday.
Yeah, cool.
Okay.
That is perfect.
Yeah, and as a matter of fact, guys, we've actually had similar situations to this happen in the past where we didn't even perfect our interests. We've actually had them close the courthouse for the day.
Yes.
Where you couldn't get in.
Yeah.
Because they so don't want this getting onto the public record, they shut the whole courthouse down.
Yeah, gotcha.
It's like, well, this is kind of strange. But yeah, I legit, this has happened to us.
You guys record it nonetheless.
Yeah, guy. There will be potentially some recording device. Not sure who's going to do it. I don't know where it's going to come from.
Yeah.
But it should happen somewhere, somehow. I don't know who though.
Yeah, you know what? I mean, okay, and this is why it's important that we do send this actually sooner than later. We've actually had response letters back in this type of situation, and this response letter says, our records indicate that there is no hearing scheduled on Monday for this individual, so what are you talking about?
Okay, that's what we're looking for.
That's the victory, isn't it?
Yeah.
Well, there you go.
Yeah, we'll throw a big party, I'm sure.
Yeah. So again, the big game changer here again, guys, is showing up and putting that original title with consideration, intent, and express purpose behind it, put it into the possession of a judge. It has fallen into the hands of a judge so that he can actually adjudicate, or he can actually balance the equities and render a decision in equity. And in equity is called a decree. Decrees are actually more powerful than orders. Decrees are in equity, orders are in at law. I mean, it's just kind of a general way to explain it. But decrees are the be all end all.
So if I don't have, I have the magistrate's name. There could be two, but there could be a step in. I don't know. You know,
to magistrate such and such, and others.
Right.
And others. Yeah. And XREL at the end of it, or
sorry, say that one again.
On your notice, the form of constructive notice, you have Attorney General of such and such, XREL.
Yeah,
which
XREL. Yeah, we're getting into capacity change ups. We're saying, hey, you're no longer acting in a public capacity. You're now acting in a private one.
Right.
Ex officio. Ex officio is another beautiful one. Where hey, you're no longer acting publicly. You're now being switched, and they actually can't control it. Why? Because you rolled in with all the rules of the game, and now they're literally at your mercy.
Right.
Cool.
So, and the judge wants to see your confidence. The judge wants to see you like kind of
know it.
You know stuff.
Yeah. And
he will appreciate that. Again, you'll be shocked.
Yeah.
At the response.
Okay. Cool.
So yeah, give me a day and a half. I'll punch out that abatement for you guys. And a quick overview, like a quick explanatory as to what's going on. And again, this is all going to get rolled into the courses here that we're bringing to people.
Absolutely.
So this isn't, it's not like this is a waste of my effort or our efforts. This is all gold. This is all gold. This is what everybody wants to see, is these little interactions right here. Yeah. Now, this is why everyone has the salvation in their pocket right now. We just didn't know it. There's literally no farther than our fingertips. Because again, as I've mentioned, all you got to do is grab a red pen and fix your birth certificate. As soon as you see that, a cop or the SWAT team could literally kick in your front door, come to arrest you. And as soon as they see that, they have to stand down. Because the person is no longer under your care and control. And again, that's why that blurb in the abatement says, the defendant no longer possesses the character in which he or she is being sued. I don't possess it. How are you going to persecute me when I don't have it?
Yeah.
Who has it? Well, that guy. Well, then go persecute him.
The holder in due course has it now.
Yeah. See, again, thanks to Dean's teachings and a few others with the holder in due course stuff. Once you stitch this whole thing together.
It is. It's liberating.
Yeah.
emotional, physical, everything, spiritual. It's unbelievable. So
For sure.
we're honored to be part of it, and we're honored for you to spend time with us. And yeah, this I knew doing a Zoom would help others, and it's here forever now. You know, so
I mean, literally,
I could watch it about 10 times.
literally, I could probably literally crank one of these out every day. It's not a big deal. And again, this is why it was so successful when Dean was doing it. That's why Dean developed such a strong following so fast. He awakened all the alphas within all these men and women out there. This new spirit was awakened, and nobody. But as soon as they heard Dean talking, it awakened the phoenix within them, and that's why that's why that movement had to be curtailed. It had to be stopped. It had to be impeded. They legally had to try to get that shit under control because it was getting right out of control because we were actually gaining our control. Kind of weird.
So thank you, gentlemen. If you can please keep us apprised of anything that you guys are experiencing, or like triumphs and failures. It's about building this together, especially for Australia. We seem to have a very big following for there. I don't know if you guys naturally have a group, but we have people just sending us constant documents and messages. And so right now I'm talking to Matt about putting up people according to countries. So we're going to start one for you guys.
Sweet.
We'd love it if you guys would lead that and head it, because you guys have so much experience and could really be valuable for that, right? So we'll let you guys know when that's up. We'll put you guys up as team leads. You can start chats and groups, and I'm telling you, you already have people that'll be joining you. So absolutely. But again, I mean, it's about the failures and the successes, right? So please, if you have not a member yet, just sign up for that. And then start putting chats up, hey, this is what we did. We were the ones who started had the interview with Darren, this is what our successes were. This is what happened at court, start building a story to get some fire behind this, because this is what's going to help this take off. Right. So wonderful. So thank you so much, you guys. That was wonderful. Great content in that.
Really appreciate it.
Thanks for the time. And, talk soon.
All right. Take care. Bye-bye now.
See you.